Welcome to Solidum Lawyers. Today, we're diving into a highly debated topic, mining in protected areas, law, conflict, and nature on the line. Let's begin. Ecuador is a mega-diverse country, and that natural wealth coexists with another kind of wealth, the one underground. Strategic minerals like gold, copper, and silver that can boost the economy, but also create serious tensions. In recent years, the debate has intensified. Is mining in protected areas legal? How far does the state authorization go? And what does Ecuador's constitution say about it? Today, we'll answer those questions with legal insight. No polarization, just verified facts. Because when it comes to mining, the legal landscape can be just as intricate as a gold vein hidden beneath the forest. The short answer, generally no, but there are important legal nuances. Article 407 of the Ecuadorian Constitution explicitly prohibits the extraction of non-renewable resources in protected areas, intangible zones, and territories of peoples in voluntary isolation. However, there is an exception unless declared to be of national interest by the National Assembly. This means the state may authorize extractive activities in these zones if a national interest is duly declared, but that declaration must meet requirements like environmental consultation and in certain cases, prior consultation with local communities. The Constitutional Court in rulings such as 1149-19 JP 21 has made it clear that merely granting concessions is not enough. Compliance with the unconstitutional environmental block is mandatory. This is one of the biggest legal knots in the mining sector. In many cases, concessions were granted before protected areas were formally designated or without rigorous environmental studies. The result? Social conflict, legal claims for annulment, and judicial review processes. The Constitutional Court's ruling in the Los Cedros case 2021 was pivotal. It annulled a mining concession in a protected forest, citing violations of nature's rights and the principles of precaution and public participation. Bottom line, a mining concession that overlaps a protected area can be revoked if it does not respect constitutional environmental principles. Here we reach the heart of the debate. Mining law governs resource extraction, where environmental law sets limits and guarantees. They must interact, though sometimes they seem to speak different languages. Ecuador has ratified international treaties such as the Convention on Biological Diversity and the Escazú Agreement, which strengthen ecosystem protection and the right to environmental information. That's why today, holding a mining concession is not enough. It's also necessary to demonstrate that the activity does not violate environmental, human, or collective rights. Under Ecuador's new constitutional model, nature is recognized as a subject of rights, and that changes the rules of the game. Mining in protected areas is not just a technical issue, it's a national issue. It's a conversation between the wealth underground and the wealth of biodiversity above. And as lawyers, our role is to help ensure that conversation is governed by law, respect, and the public interest. And in Solidum Lawyers, we believe development and sustainability should not be adversaries, but balanced forces. If you found this video valuable, subscribe to our channel, share it with your network, and tell us in the comments. Should mining be allowed in protected areas under certain conditions? We're listening. See you in the next video.